Ang susunod na programa ay rated PG. Patnubay at gabay ng magulang ay kailangan sa mga batang manonood.
The views and opinions expressed by the host do not state or reflect those of the company and its management. Furthermore, the views, opinions, and insinuations made by the host, guests, do not reflect those of the show, the management, and the network.
The impeachment trial of Vice President Sara Duterte continues to intensify. From key NBI testimony to debates over alleged threats and subpoenaed financial records, days 4 to 6 have raised major legal and political questions. Tonight, we break down the biggest developments and what they could mean for the case and for the nation. Good evening. I am Dr. Dennis Coronacion, and this is the PH Insider on TV. To help us unpack the latest developments and their legal and political implications, we are joined by Professor Eric De Torres of the University of the East. Professor, welcome to the PH Insider. It's a pleasure to have you with us.
Good evening, Sir Dennis, and good to be back at your program.
Also joining our roundtable discussion is Attorney Adonis Gabriel, political law professor and prefect of Student Affairs at San Beda University. He is a valedictorian of the San Beda College of Law, a bar top-notcher, and served as a 2024 bar examiner in political law and public international law. Attorney Gabriel, welcome to the PH Insider, and glad to have you with us.
Good evening, Dr. Dennis, and to our viewers. Thank you very much for having me. It's a pleasure to participate in your discussion.
Joining me to guide today's discussion is no less than the President of D8TV, Romel Miranda. Good evening, Press. Ano bang mainit nating pag-uusapan?
Good evening, Dennis, and thank you for the introduction. Of course, we would like to welcome si Professor Eric and, of course, si Attorney Gabriel for joining us. The impeachment trial of Vice President Sara Duterte entered another pivotal phase as the Senate tackled key legal issues that could shape the outcome of the case. Here's the report from Judea Bernardo.
Day 4 ng impeachment trial ni Vice President Sara Duterte, sumentro sa Operation Romanov. Nagpatuloy ang impeachment trial ni Vice President Sara Duterte sa Senado kung saan tumestigo ang ikalawang witness ng prosecution na si NBI Regional Director Attorney Jeremy Lotok. Ayon kay Lotok, seryoso ang umano'y mga bantang binitawan ni Duterte laban kina Pangulong Ferdinand Marcos Jr., First Lady Liza Araneta Marcos at dating House Speaker Ferdinand Martin Romualdez. At hindi ito saklaw ng proteksyon ng kalayaan sa pananalita kung ito ay may elemento ng krimen. Iginiit naman ng depensa na walang inupahang hitman ang vice-presidente at inihayag na maghahain sila ng mga testigo upang patunayan ang umano'y Operation Romanov na sinasabing plano laban kay Duterte at sa kanyang pamilya. Judea Bernardo para sa D8TV.
Ninyong lahat, Martin Romualdez, Lisa Marcos, Bongbong Marcos.
Let's put the issue on the table. And before we start on the details of the testimony of the NBI witness, Attorney Gabriel, what is your impression on this prosecution witness?
Okay. So, Director Lotok is a very competent and credible witness. So he was able to discuss in detail the operations or the investigations that the NBI conducted. And the most important takeout of Day 4 is the admission of the defense of the existence of the recorded discussions or statements of the Vice President which were repeatedly shown during the first two trial dates. So it is very important because it is no longer a contentious issue whether the recordings exist.
Professor Eric, ikaw sa pananaw mo po, ano po yung impression po ng mga ordinaryong nanonood katulad po ninyo sa kredibilidad at sa competence po ng second witness po ng prosecution na si NBI Director Lotto?
Well, para sa akin, Sir Romel, very credible din siya katulad ng sinabi ni attorney kanina. Makikita din natin yung buong proceedings, very technical, very legal for that matter. Kasi makikita natin yung objections and at the same time, makikita din natin yung technical aspect na kung saan yung paghimay nung manner kung paano vina-validate yung authenticity. Pero that being said, nagkaroon na ng admission on the part of the defense. So tingin ko mas maganda na to move on since it was already established. And from that vantage point, makikita natin na mas lalo ngayon na lumalaki or lumalim yung interest because pumasok sa eksena itong Operation Romanov na ito.
I agree with the statement of Attorney Gabriel. No? If you look at the demeanor of Director Lotto, cold, stern, no, almost no emotion. But if you look at the details of what he's saying and how he delivers it, for me, he's a credible witness. Do you share that impression, Dr. Dennis?
Well, yes, sir. Especially that I think he was able to redeem the case that was being pushed by the prosecution. Because remember that during day 4 or I think it was day 4 na the first prosecution witness was presented and that was NBI agent Mr. Kalilong. At first when he was being presented by the prosecution panel, very solid yung kanyang pag-lay down nung as to how the investigation was conducted and so on and so forth. But when he was cross-examined by the defense panel, doon nag-unravel yung kanyang testimony. There were loopholes that were seen by the prosecution panel, and that these loopholes were later on admitted by the NBI agent. Buti na lang kasunod doon si Attorney Lotto. So kumbaga man na-redeem kung ano man yung yung argument that was being raised by the prosecution panel.
Attorney Gabriel, the importance of the testimony of NBI Director Lotto, no, as regards I think the 4th article of the impeachment, no, with regard to, ang issue is, nung una is, teka muna, ang argument ng defense, hindi naman high crime yung grave threat eh. For you, is it the issue of whether grave threat is a high crime or does it pertain to the trust reposed on the office of the Vice President?
Okay. So, the assessment of whether the acts of the Vice President constitute an impeachable offense, specifically as betrayal of public trust or other high crimes, is a duty reposed under the Constitution to the senator judges. The importance of the testimony of Director Lotto is to authenticate the video recordings and to explain to the senator judges why they investigated the Vice President and why they consider the statements of the Vice President as an impeachable offense or at the very least, a criminal offense. Okay, so this lays the ground for the determination of whether the acts of the Vice President may be considered as an impeachable offense.
Okay po.
Yeah.
Professor?
Well, I actually have a question for my former professor in San Beda. Expert tong si Attorney Gabriel. Now, the NBI argued that the alleged threats are not protected by freedom of speech. Now, from a legal standpoint, attorney, how strong is that argument?
Okay. So, truly, the Constitution protects the freedom of speech. As a matter of fact, in an old case, in the case of U.S. versus Bustos, the Supreme Court discussed and described the freedom of speech when it comes to criticism of a public officer as a scalpel So the Supreme Court compared it as a surgical instrument in order to show the abscesses of officialdom and in order to provide solution or cure for the defects. However, freedom of speech, like all the rights under the Bill of Rights, are not absolute. So freedom of speech is subject to limitations. So one cannot shout fire in a theater, and that may cause damage or injury to persons. In the same manner that one cannot threaten the life of another person in the exercise of one's freedom of speech.
Sir, dako naman tayo sa political implication. Prof. Eric, do you think that the argument of the defense panel that the video of the Vice President was a mere exercise of her freedom of speech and expression, tingin mo ba tinanggap ito ng taong bayan?
Well, if you look at the public sentiment, especially when you look at the discourse in social media, talagang it's a spur of emotions because of allegations of also threat against her. So for me, when you look at this article 4 and looking at from a political vantage point, the prosecution would argue that it is the best article that they have. But for me, in just an observation, from a political standpoint, it's much better na inuna sana yung unexplained wealth.
Oh.
So, for me lang, kasi they should move on nung na-establish na naman nila na valid or authentic yung video. So, from there, doon ka na kasi may pihit ka doon sa public sentiment sa issue ng flood control and everything. So, from a political standpoint, yun yung tingin ko na dapat inunang concentration ng prosecution of the unexplained wealth. Rather than, kasi ang nangyayari dito is he said, she said And it becomes more technical. For me also, habang tumatagal to, mas lalo nagiging favorable on the part of the defense. Nung kinwenta nila, halos aabot ng 1 year. So, umabot ng 1 year itong buong trial na to, election na, filing na. So, magiging favorable siya on the part of the defense because the burden of proof is again on the part of the prosecution and the defense doesn't have to do anything. Plus, ayan pa, nag-uulan na rainy season, marami na namang lalabas na usapin ng flood control issue and everything. So, matatabunan at matatabunan. So, you would rather stick doon sa unexplained wealth kasi may sentiment ka ng issue ng flood control. So, for me, from a political
So it should
standpoint.
be the other way around.
Yes.
Attorney Gabriel, yung pong one of the questions of the senator judges is that he posits that this particular utterances of the Vice President is conditional. Now, does that, modifier in that statement negates the offense of grave threat?
So, grave threat is a crime. And the seriousness of this offense is not reduced or mitigated by the fact that it is subject to a suspensive condition. So, since the offense is already consummated once the elements of the offense are already present. So, whether or not it is subject to the happening of an event that may or may not happen, the offense is already committed. So, the statement of Agent Calilong actually is precise when he said that the threat is absolute. The offense is already consummated, the elements are there, regardless whether it is subject to a condition, the crime has already been committed.
So you mean to say, attorney, that even without an actual hitman, it could still be considered a crime?
Yes. So the very statements of the Vice President constitute the offense of grave threat as defined under the revised penal code. And more importantly, the Vice President is being tried in the Senate now, not for a criminal offense. She's being tried for an impeachable offense. So the term grave threat should not be taken in its technical sense as defined under the revised penal code. So it should be defined within the context of Article 11 of the Constitution as an impeachable offense. So
As a form of betrayal of public
as a
trust.
form of betrayal of trust.
So, may some basis po, attorney, with regard to this Operation Romanov. For example, if we will, we will accept that such thing exists. No, the impression is that this was hatched by those
Law
who are
enforcement
planning.
agencies.
Yes, by those planning to do harm to the vice president, and you're referring to the president or the first lady. And what is the means to do this? You have to use state agents. Okay.
That's correct. Okay, so
How, for example, that Professor Maui, how did you even manage to get this kind of information, which is supposedly top secret information, no? And the other thing is that, of course, they have to hurdle that first, no? Second yung question na whether that actually would justify. Because if that is the case, if the Vice President really knows about this Operation Romanov, would it be more proper for her to expose this, Professor Eric, to expose this, so that the ensuing utterances would actually have some form of basis, or at least in her own way, of course. No? Of course, ordinary people like us would probably have a different course of action.
Sir Romel, I think the question is why now and why use that medium to have a basically online press conference. So I think the most logical thing to do is to brought this to the proper authorities. Why did you, kasi yun yung malaking question eh. Bakit ginamit mo na nagpa-online press conference ka if, for example, the threat is, really serious? So you must have gone to proper authorities for proper documentation and so on and so forth. The question there is that why use that platform, an online press conference, and make those basically remarks and threats conditional or otherwise?
Yeah. As you mentioned earlier, President Dennis, or President Romel, sorry. So these activities are intelligence information. Okay, so which means that these are top level state secret. Okay.
If ever they do exist, right?
If ever they do exist. And the tact of the defense during the cross-examination of our NBI agents is that they are putting the burden on the prosecution to prove that that operation exists. The defense presented Project Romanov as a defense. So therefore, it is incumbent upon the defense to prove that such activity indeed exists.
Yes.
It is not for the prosecution's witness to prove that there was such an incident.
But they will get the chance to prove that during their turn, attorney.
Yes, for the presentation of evidence in chief for the defense.
Pero attorney, do you think na with or without, given all these things that were discussed during day 4 and day 5, with regard to the to Article 4, do you think na which side presented a better argument?
Okay, so of course we are still in the stage of presentation of evidence for the prosecution. Definitely, they control the evidence that they will present.
Okay.
So therefore, they have the upper hand now because they are the one presenting the evidence. But it is too early to determine whether they have sufficiently established Article 4 of the impeachment complaint, because the defense will also present their evidence in chief once the prosecution already rested its case. So, but definitely for the first 6 days or for the first 5 days of the impeachment trial, the prosecution had an upper hand because they are the ones who presented the evidence.
Attorney, siguro parting question for this particular topic on the credibility of the NBI witness, Regional Director Lotok. No? One of the senator judges actually stood up and asked the witness, do you have a pending case right now? Or are you being accused of something already? Which was answered clearly by Director Lotok. Does that in any way affect the credibility of this witness, attorney?
Okay. So, of course, the purpose of that question is to test the credibility of the witness. So, in trial, the one cross-examining a witness will present evidence to prove that he has the capacity to tell a lie because he had a history of criminal offenses, just to discredit what the statements that the witness have testified to. But fortunately for Director Lotok, he was able to confidently explain the reason why there are allegedly cases pending against him, and eloquently he said that it comes with the job. So he said that in the NBI we avoid noises, we just do our job. Okay.
The legal arguments are becoming more defined, and the questions surrounding the case continue to grow. When we return, we'll recap day 5 of the impeachment trial and examine the latest testimony, the ICC angle, and what these developments could mean for the proceedings. Stay with us. The Page Insider will be right back.
Nursing is not the easiest job in the world. In fact, it's emotionally draining.
Huge step in the fight against COVID-19.
I truly believe in the things that I do because of where we come from, our resilience, our dedication.
A Filipino nurse administers the first COVID-19 vaccine, and her name is May Possums.
I gave my best and my heart.
I am May. I am the Philippines.
The impeachment proceedings continue with new testimony and fresh legal arguments on day 5. Here's Judea Bernardo with the highlights.
Day 5 ng impeachment trial ni Vice President Sara Duterte. Zulaika, iniatras, matibag, ni-reschedule. Nagpatuloy ang impeachment trial ni Vice President Sara Duterte kung saan sinabi ng NBI na isa sa mga ikinonsidera ng kanilang investigasyon ang kaugnayan ng Vice Presidente sa dating Pangulong Rodrigo Duterte at ang kinahaharap nitong kaso sa International Criminal Court o ICC sa pagtukoy sa kakayahan umano niyang isakatuparan ang mga banta laban kina Pangulong Ferdinand Marcos Jr., First Lady Liza Araneta Marcos at dating House Speaker Ferdinand Martin Romualdez. Inamin ni NBI official Attorney Jeremy Lotok na wala siyang personal na kaalaman kung may inupahang hitman si Duterte, ngunit iginiit niyang sapat ang ebidensyang nakalap ng NBI upang iugnay siya sa umano'y plano. Samantala, iniatras naman ng prosecution ang plano nitong iharap bilang testigo si Office of the Vice President Chief of Staff Undersecretary Zulaika Lopez. Gayon din si House Legislative Security Bureau official Captain Belinda Bello dahil umano'y magiging paulit-ulit na lamang ang kanilang testimonya. Inanunsyo rin ni Senate Presiding Officer Francis Cheese Escudero na magpapasya ang impeachment court kung papayagan ang kahilingan ng prosekusyon na masabina ang bank at tax records ng Vice Presidente. Judea Bernardo, D8TV News.
Let's get our panel's insights on these developments. Professor Eric, sa day 5 po, ano po yung para sa inyo ay lumutang po dito sa hearing po na ito?
Well, it was very surprising na iniatras yung yung testimonya at yung pag-summon kay Yusek Zulaika Lopez, no. So for me that was I think a good move on the part of the prosecution because parang hindi natin alam yung pwedeng sabing statement ni Yusek Lopez. For that reason, it could either make or break the prosecution, but at the same time, very noticeable is how they were not able to crack Director Lotok. Ang isa pang malupit dito is yung stoic yung term ng mga millennials ngayon, yung nonchalant na dating ni ni Director Lotok, so very on top, and he knows what he is saying kasi probably he's the one personally investigating it. For me, consistent yung naging approach at saka statements ni Director Lotok.
I agree with the observation of Professor Eric, kasi it appeared that when he was being cross-examined by the defense counsel, he appeared relaxed and unfazed. Unlike yung naunang NBI witness, ito napakalma. Ngayon ang tanong ko kay Attorney Gabriel. Attorney, did it help that the director, the NBI director for cybercrime is a lawyer?
Definitely. Because that means that he knows the law and he knows the procedure in conducting investigations in order to make all the evidence that they gather admissible in court. So, tama yung observations ninyo, that Day 5 solidifies the credibility of Director Lotok. Because the more that the defense counsel cross-examines Director Lotok, the more that he shows that he knows everything, he knows the procedure, and whatever they have done complied with all the requirements under the law.
Attorney, ako naman with regard to the pag-withdraw po, pag-withdraw dun sa prosecution on the pag-witness po ni former Yusek Zulaika. I think it's not just tama, kasi parang magiging is hostile witness ng 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 prosecution So talagang mahirap mahirap mo siyang makuhanan ng gusto mong statement, napapabor sa iyo. I mean, pwede, but it's
hostile witness.
Yes. That's correct.
Matrabaho.
Yes.
Tama ba?
That's correct, President Romel, That was a smart move for the prosecution because as you said, Yusek Zulaika Lopez was intended to presented as a hostile witness. So when we say hostile witness, it is not she is not a friendly witness. And since the fact that they want to elicit from her testimony was already admitted to by the defense, particularly whether those statements were uttered by the Vice President. Because as Attorney Kapunan, Lorna Kapunan explained, they intended to present Yusek Lopez to prove that she was present during the press conference when the Vice President uttered those statements. So since the defense already admitted the existence of the videotape statements of the Vice President, then there is no need to present corroborative witness, and more so that the corroborative witness is a hostile witness. So it might do harm rather than benefit to the prosecution if they insist on presenting Yusek Lopez for a fact which has already been admitted to and established by the first two witnesses.
So it might backfire another.
Yes.
May personal knowledge daw ba si Director Lotok doon sa may kinausap na bang hitman si Vice President? I think unang-una para sa akin at bilang ordinaryong tao, parang irrelevant po yung tanong kasi sino naman ang magsasabi kay Director Lotok para magka-personal knowledge siya o ano naman ang access niya. Kunwari ako magpaplano ako ng isang masamang bagay, hindi ko naman siya i-announce sa maraming tao,
Exactly.
Yung sa tanong na may hitman ba? Tapos sinabi niya na wala naman akong personal knowledge. Humina ba yung statement ni Director Lotok?
I don't think so. So, as I mentioned earlier, the act of actually engaging a hitman is not an element of the offense of grave threat. So, grave threat means a statement of a harm on a person, and with or without condition, and regardless whether the person uttering those statements complied with the threat, the offense is already consummated. Okay, so even if the prosecution was not able to prove that the Vice President indeed engaged the services of a person who was ordered to kill the first family, as well as the former Representative Romualdez, that does not negate the fact that the crime has already been committed. That does not diminish the act of the Vice President.
President Romel, since you mentioned that in your question that something was raised by a senator judge, ako meron din akong gusto i-point out about a senator judge asking a question to Attorney Lotoc. O kasi siguro hindi nila na itong defense panel hindi niya nabasa during cross-examination yung sinabi ni Attorney Lotoc. Ang tanong ko, yung bang, di ba, isn't it that our senator judges should be asking sensible questions? And speaking of that, ang tanong ko kay Prof. Eric naman tayo. What do you make of Senator Robin Padilla's statement regarding the lack of knowledge on Islam of, I think he's now appointed as Regional Director of BARM, si Attorney Lotoc?
Well, yun yung isang, I think, the most problematic thing about, a lot of people are asking na, how do you make sense or how do you observe the posture of the senators? Is it parang they're like passive and all? I think that observation comes to the very idea that, one, they are probably observing, two, they are also a bit, very calculated, because ano man yung sabihin nila, ano man yung lumabas sa bibig nila, they will be heavily scrutinized because of, various social media platforms, gagawan ka ng meme. So, more importantly, it's not just giving comments, but comments with something that is very substantive. Pero at the end of the day, this is something that, for future reference or purposes, na matuto tayo dun sa iboboto nating mga senador eventually by 2028.
Ikaw nagsabi yan, ha?
To add then, Doc Dennis, we have to also consider the context of the statement or the question of Senator Padilla. So first, the question of Senator Padilla to Director Lotoc was, were you promoted as an officer of NBI, and how many times? So when Director Lotoc said that I've been promoted several times, and as a matter of fact, he was promoted as early as before the term of President BBM. So the next question of Senator Padilla was your assignment in BARM a promotion? Okay, so but it was shown by Director Lotoc that it was not actually a promotion, but more of a more inconvenient post, because he was a director of Region 4 and he was transferred to BARM. So, in the public service, that's not a promotion.
Actually, Attorney, we have been saying, pag tinapon ko sa Mindanao,
may kasalanan ka.
hindi promotion yun.
Well, it's called lateral movement, no? Lateral movement. When you are assigned to different regions, and as regional director, wala ka namang doon, wala kang say doon, no? Kung saan ka kailangan ng paglilingkod mo, doon ka i-assign. So,
again, just to also, from the answer or from the line of questioning, there was a sort of insinuation trying to discredit him actually. The mere fact that you asked a question na, how many times were you promoted? As if insinuating, and this is just me, observing as such, na parang ang dating, yung promotion, gaano ka kabilis, tapos yung pagka-promote mo, parang sinasabi mo na nandiyan ka sa witness stand ngayon kasi tumaya ka, ang kapalit, promotion mo. It's a simple, in the way that I get to read it, parang ganun. So,
I think the term used was golden boy. Parang, golden boy.
So Romel, Sir, if I may, medyo unfair din on the part of Director Lotoc. Kasi kung director ka, career yan yung magseseso ka, 1, 2, 3, and 4. Di ba? Pinaghihirapan mo yung posisyon bago mo makuha yan. So, may qualification standard na binibigay si CSC. So, parang medyo mahirap din on the part, especially if you're a career civil servant, because you will be undergoing this process. And then, di ba, to be able to encounter such line of questioning, parang, for me, it's also offensive in that.
And ako, last note ko on this particular matter, there was one senator who makes it an issue about the school where you graduate. Now, this guy is now asking us to make it an issue based on religion. No position in government requires you or screen you because of your belief or your status or whatever. No, I think it's really unfair, and I commend the calmness, and the straightforwardness of this witness. Ako yun lang po masabi ko, Attorney.
Totally agree, Press. So, definitely, Director Lotok was able to embody the trait of a public officer. So, he's saying, we go wherever service directs us. Regardless of who is in power. If we are ordered to go to BARM, then so be it, because we are public officers. And take note of the term connected to offices in the government. These are public service. So it's a service. It's a service. It's not a privilege. It is a service to the people. So definitely, it is unfair to question the credibility of a public officer just because he is doing his job.
And the best description that he gave is quietly, performing these things quietly. In contrast with what we are seeing right now.
Agree.
The legal battle continues and the stakes are only getting higher. When we return, we'll recap day 6 of the impeachment trial, where the spotlight shifted to the debate over subpoenaing the Vice President's financial records and what it could mean for the case moving forward. Stay with us. The PH Insider will be right back.
Hello, Lotto players. My name is Ashley Tuason, one of the hosts of the PCSO Lottery Draw. And our show is all about fun, excitement, and luck as you play your favorite digit games. But aside from that, our show is also giving back to the community, especially to different sectors of our community through our charitable programs. And if you are watching or if you love watching our show, this might be your lucky day because you might be the next Lotto millionaire. And you can watch us every day at 2 p.m., 5 p.m., and 9 p.m. only at D8TV. Once again, my name is Ashley Tuason, one of the hosts of the PCSO Lottery Draw.
Now let's turn to day 6 of the impeachment trial. Here once again is Judea Bernardo with a recap.
Nakatutok ang ika-6 na araw ng impeachment trial ni Vice President Sara sa pagdinig ng Senado sa kahilingan ng prosecution na masabina ang bank at tax records at mga dokumento ng Anti-Money Laundering Council o AMLAC ng Vice Presidente, kaugnayan ng aligasyon ng hindi maipaliwanag na yaman. Wala munang testigong humarap sa impeachment court at kapwa panig ay maglalahad lamang ng kanilang mga oral arguments. Ayon kay Senate Presiding Officer Francis Cheese Escudero, sa July 20 pa magpapasya ang mga Senator Judge kung pagbibigyan ang subpoena requests. Iginiit ng prosecution na mahalaga ang mga dokumento bilang ebidensya, habang sinabi ng depensa na isa lamang itong fishing expedition na lumalabag sa due process. Samantala, inanunsyo rin ng prosecution ang mga unang testigo para sa usapin ng umano'y maling paggamit ng confidential funds. Habang nakatakdang tumestigo si NBI Director Melvin Matibag sa July 21. Judea Bernardo, D8TV News.
Let's dive into the discussion. Professor Eric, para sa iyo, what's the biggest takeaway from day 6?
Well, kung hindi ako nagkakamali, naging usapin din na malaki yung grades. Press. Parang tama ba na tama yung avenue? Maraming abogado doon at naging usapin yung grades. Pagka ba mas mataas yung grades, mas magaling ka. Di ba?
Definitely, no.
Definitely, bar top notcher. So baka pwedeng yun, kung ano yung place mo sa bar, yun yung maging
exceptional to. Valedictorian na, bar top notcher pa. Siyempre, di ba?
Di ba? Napihit din yung issue. Pero I think, and this is more appropriate siguro kay attorney, is the pagsupina po ng bank records. And especially Manscarpio, because he's a private citizen. So, Yun yung talagang we're waiting for Monday. And I think attorney would be best to answer this question.
Thank you very much, Professor Eric. No, I agree with you that the limelight was stolen by side comments of counsels. No, but for day 6, first of all, I would like to commend 2 gentlemen. I would hats off to Dean Jokno and to Attorney Powa. The acts of these 2 gentlemen reflect the real attitude of lawyers in court. So it is not the usual activities when you saw the first 4 or first 5 days where objections and the remarks are marked with cynicism. Those are not the things that happen in court. So the reflection of the real legal profession was shown by the legal arguments of these 2 gentlemen. So hats off to Dean Jokno and Attorney Powa. So this shows that you can present your legal position, you can advocate for a client, but at the same time maintain respect to the other side.
And remain calm.
And stick to the issue. Stick to the legal issue without ad hominem, without personal attacks, without side comments. This was shown by these 2 gentlemen. As to Professor Eric's question earlier as to the bank accounts as well as tax records, of course, this is a constitutional and a legal issue. So much has been discussed on the bank secrecy law, the law on anti-money laundering. So note that the Congress enacted these laws in order to limit the power of courts of justice, regular courts.
Regular courts.
So when it comes to regular courts, the Congress has the power to enact laws in order to provide limitations. What are the things that they cannot subpoena? What are the things that they cannot ask? So is that within the power of the Congress? Definitely. And the source of that power is Section 2 of Article 8 of the 1987 Constitution. So the Senate as an impeachment court is also a court, but it is not just an ordinary court. It is an exceptional court because the Congress or the Senate specifically as an impeachment court is specifically mandated with the Constitution in order to implement public accountability. So which means that while the Congress as a legislative body can impose limitations on regular courts, definitely the Congress cannot enact laws in order to limit the authority of the impeachment court. So in the College of Law, we discuss this when it comes to the doctrine of separation of powers. So under the doctrine of separation of powers, one government agency entrusted with a constitutional authority cannot encroach on the other constitutional agencies. So the Senate as an impeachment court is a constitutional office.
Attorney, do you mean to say that since that's your explanation regarding the powers of the impeachment court, do you mean to say that it can set aside the limitations set by the Congress on the regular courts? So therefore, it could subpoena the private, the bank accounts of the Vice President and her husband?
Definitely. So the Internal Revenue Code, which declares the income tax returns of taxpayers, including public officers, imposes a limitation on the authority of regular courts. It does not impose a limitation on the impeachment court because to allow the Congress as a legislative body to impose limitations on the impeachment court, then they can easily defeat public accountability by enacting a law. So the Congress can just enact a law that the impeachment court cannot look onto these documents. But that would violate the doctrine of separation of powers.
Process of the impeachment court exercising that power, isn't it violating the rights of the individuals involved, especially as raised by Professor Eric, the right of Attorney Manscarpio, who is not an impeachable official?
Okay. So the oral arguments of Dean Jokno and Attorney Powa have shown the conflicting interests involved. So on the part of the prosecution, the Dean Jokno emphasizes public accountability, transparency. On the part of Attorney Powa, he emphasized on the individual rights of Vice President Duterte as an individual, as well as her family. Okay, so essentially on right to privacy. Okay, so when it comes to the right to privacy, the Supreme Court has spoken on the extent of the right to privacy of public officers. So the Supreme Court said so many times that public officers should not be too thin-skinned, onion-skinned. So because public officers enjoy lesser right to privacy, once they enter public service, they open themselves to the inspection and even criticisms by the people. So the Vice President cannot invoke the same level of constitutional right to privacy as an ordinary private citizen. Because again, the people entrusted her with public duties, and the people have a right to know what are the acts of the Vice President, regardless whether it's in her office or in her private life.
So dun sa point ni Attorney Gab, no, you raise a very good point, very important point, very objective point, very legal and academic otherwise. But my fear with regard to this is that once this will be voted upon, there will always be a perception of politics.
Yes.
The way that, senators will divide the House and make their voting, make their decisions. It's not really based solely on what just Attorney Gabriel discussed, but rather it's more of, again, blocks between the senators. So, again, it would affect and made an impact to the perception of the public with regard now to the, overall credibility of the impeachment trial. Na, it's not really being objective. Kasi it's a good thing that, Attorney Gabriel made mention about this, very academic, very objective. But the question is, are the Filipino public, aware of this kind of, situation and,
Prof. Eric, I would just like to add, I think it's about time for the Filipino people to have a victim mentality. So, yes, the authority is vested in the Constitution for center judges to decide on all cases of impeachment. Does that mean that the people do not have a voice on this process? So, again, let us remember that the source of the authority of the center judges is the people themselves. So, the Supreme Court, again, in an old case, said that these government institutions are not the chief palladium of constitutional authority. The people who are the authors of this blessing are also the guardians of the Constitution. Their voice must be ever ready to mark. Their eyes must be ready to spot aggression on their constitutional right. So again, the people are not just passive viewers. The people are not just passive participants of these proceedings. They have a right, they have a duty to make known their position. So again, let us exercise that right, because once our center judges decided, and they decided in a manner which is not consistent with our position, we cannot blame the center judges if we did not do our part.
So, hypothetically, Attorney Gab, Sir Dennis, Pres Romel, should this exercise be brought upon on the part of the people? Or let's say, let's just have an election and let the people decide, and not the senator judges basically decide on it.
Professor
Hypothetically.
Eric, let me just relate this to not so distant past, no? When there was an impeachment hearing on President Erap, there is this question of the envelope,
second envelope,
the second envelope, no? And it turned out it doesn't amount to anything, no? Have they allowed the second envelope to be opened? Erap could have finished his term,
That's
probably,
right?
right?
Yes. That's a possible
Now,
scenario.
ako bilang ordinaryong tao, I'm already so curious about these accounts. The tax records, the bank records, and the AMLAC documents. As a person, no? As an ordinary person. Second, did the prosecution manage to at least lay the basis for the requests of these particular documents, Attorney?
Yes. So I think they have requested subpoena, both ad testificandum and duces tecum. So first of all, subpoena ad testificandum refers to a compulsory process to require the attendance of a witness, while subpoena duces tecum is a compulsory process to produce documentary and other physical evidence in court. Okay, so the prosecution has already submitted both subpoena ad testificandum and duces tecum for the production of the income tax returns as well as the bank records of the vice president, her spouse, and all the businesses where they have interests. Okay, so which means that the impeachment court has the authority to determine the propriety of this request. So remember, during the oral arguments of Attorney Powa, he raised the two conditions in order that subpoena may be granted by a court. So these requirements were laid down by the Supreme Court in requests before regular courts. However, these principles also apply to Senate as an impeachment court. So he mentioned test of relevancy, test of definiteness. So when it comes to test of definiteness, the request for subpoena must specify the documents requested, the witnesses who are requested to appear before the impeachment court. So I think in the request for subpoena, the prosecution was able to specify what year of the income tax returns they are requesting and what specific bank accounts they are requesting from the AMLAC and the different banks. Okay, so when it comes to test of relevancy, the ultimate question on this test is whether the evidence requested, whether it be a testimony or a documentary evidence, will prove either the guilt or innocence of the respondent. If it does, then it satisfies the test of relevancy. Okay, so which means that it will only become as a fishing expedition, as Attorney Powa repeatedly mentioned in his oral argument, if the documents requested do not have anything to determine the guilt or the innocence of the vice president. Okay, so maybe a question is, why was the prosecution requesting bank transactions, income tax returns prior to her election as a vice president? Again, this is intended to establish a baseline. So note that these documents were requested in relation to Article 1, Article 2, that's under ill-gotten wealth.
Attorney, ako, last question po dito. No? There is a competing rights po na nire-raise po ng defense and prosecution. One, prosecution, yung accountability ng public officer, si Vice President. Si Attorney Manscarpio, yung privacy niya as a private individual. No? It just so happened na mag-asawa sila. Yung sa determination probably nung impeachment court attorney, alin po ba yung dapat manaig dyan considering ito po yung allegations?
Okay, so this is not a new question, or this is not a novel issue, Pres Romel. No? Even during the impeachment trial of former Chief Justice Renato Corona, this issue was already raised because note that the prosecution during the impeachment trial of the former Chief Justice also requested bank records as well as transactions of corporations allegedly where the former Chief Justice have interests, financial interests. And the Senate Impeachment Court allowed the production of these documents. So the former Chief Justice, after his conviction, went to the Supreme Court and he questioned the constitutionality of the act of the impeachment court in allowing the examination of documents of corporations which are separate and distinct from him. Okay, although he has financial interest. The Supreme Court dismissed the petition. However, the Supreme Court dismissed it on technicality because the Supreme Court said that the Senate has already voted and they have already convicted the Chief Justice. So therefore, we are not going to rule anymore on the question of constitutionality. Because in the College of Law, we learned that before the Supreme Court can decide on constitutional question, the Supreme Court must satisfy 4 requirements. So first is that there must be an actual case or controversy. It should not be hypothetical. The issue must not be hypothetical. Second, that the constitutional issue must be raised by a proper party, the one who was injured. And it must be raised at the earliest possible opportunity. And lastly, the constitutional issue must be the lis mota of the controversy, meaning that the court cannot resolve the principal or primary controversy unless the Supreme Court will delve on the constitutional issue. That's the reason why in Corona versus Senate, Supreme Court said, we're not going to decide anymore on the constitutional question. But if you read the decision, the resolution in that case, the line of discussion of the Supreme Court is more on respect on the Senate as impeachment court on its processes. So the Supreme Court did not issue a TRO, the Supreme Court did not declare the act of the Senate unconstitutional.
President Roman, I'd like to add, kaya, I'm impressed by the discussion of Attorney Gabriel. All the legal principles that are relevant here, even the constitutional principles. Pero ako naman, I'd like to think, if I may sound cynical about this, or if I'll be allowed to play the devil's advocate, ano kaya yung likelihood na yung mga senator judges natin will allow a subpoena to be issued on those tax documents, tax records, and AMLA? Kasi there's a possibility that someday they too will become impeachable officials. Baka may maging presidente dyan, vice president, o Supreme Court justice. Papayagan kaya nila yan, knowing that someday their decision could set a precedent doon sa future action nila that will affect their future action.
Okay, but Doc Dennis, senators should learn history. During the President Estrada impeachment, there are senators who voted not to open the second envelope. And what happened? What happened during the election after the impeachment trial? Most of those who did not allow the opening of the second envelope lost during the election.
Prophetic?
Well, the thing about it is really the impeachment trial is really at the end of the day beyond the legal battle of the prosecution and defense. It's the court of public perception. It's basically political and highly political in nature. So I really appreciate and we appreciate the discussion made by Attorney Gabriel a while ago, especially in terms of yung talagang pumasok sa akin is when you're a public officer, a public official, expect that you're under public scrutiny. So yung privacy mo talagang mawawala na dyan. Second point that I would like to raise, kung wala ka talagang tinatago, buksan mo siya. Kung ganun lang talaga siya kasimple. Regardless of whether privacy is being violated or, for example, is a fishing expedition, kung wala kang tinatago, basically ganun lang siya kasimple. And I think this should be a lesson to all public officials. I think it's just consistency with regard to the following the law, abiding with the law, and at the same time, the ethics and morality basically of being a public official. I think we should go back to that basic principle na pag public official ka, alam mo yung parametro ng kung paano ka nabubuhay at yung in good faith, dinideklara mo yung yaman mo. It's kung ifa-follow lang natin, tingin ko yung basic principle na ganun, hindi magkakaroon ng ganitong kalalim na problema at legal and that affects the nation, that affects a country right now.
Okay, let's just hope this this journey comes to its intended destination soon. As the impeachment trial continues, the nation watches not just the case, but the strength of our democratic institutions. In the end, facts, evidence, and the Constitution must prevail over politics and opinion. I'm Romel Miranda, and this has been the PH Insider. Thank you for joining us. Good evening. Thank you, Attorney. Thank you. Marami pa akong gusto sabihin, pero